felony offender. He has a parole eligibility date of September the 8th of 2023, an adjusted good time date of April the 11th of 2029, and a full term date of September the 8th of 2033. He is currently serving a 30-year sentence on the charge of manslaughter, having been sentenced on July the 12th of 2004. Mr. Anderson, is that information accurate?
Yes, sir.
Mr. Anderson, your case has been assigned to me, so I will begin our interview process. Mr. Anderson, how old are you today, sir?
64 years old.
And how long have you been in prison on these charges?
A little over 20 years.
So you were 44, 43, 44 years old at the time this occurred?
Yes, sir.
Tell me a little bit about Ruben Anderson at 43, 44 years old. Were you working?
Yes, sir.
What kind of work were
working.
you doing?
I was in the construction business. I was superintendent for Caribbean Construction Company.
How much education had you had?
I graduated from high school and I had 2 years of college.
Were alcohol or drugs involved at all in your life at that time?
We were drinking the night this occurred, but I never did drugs, ever.
Okay, well, talk to me a little bit about your drinking. How often would you drink?
I guess every day, 2 or 3 beers after work.
Okay. You consider yourself to be an alcoholic?
No.
Now, after having been in prison and taking a few courses and having time to reflect, do you consider yourself back then to have been an alcoholic?
No.
So tell me what happened on September the 6th of 2023. First off, what was your relationship back then? Tell me what was going on with you.
I was at Jay's house to watch a football game.
Let me slow you down a little bit. Tell me what your relationship was with Mr. Jay Damaris.
We were friends.
Okay.
And I was at his house for a football game, but I was at his house every day working on his house after work. After work, when I got off, I went to his house and I was doing work on his house.
You were not living there?
No.
Okay, go ahead.
I would work on his house till 9, 10 o'clock at night. And then sometimes I would stay there and because it was so far for me to go home.
Okay, so what happened?
We were watching the game.
Who is we?
Jay and I and a young lady named Rachel, I believe.
Okay.
And Rachel.
Who was Rachel to either of you?
Rachel was someone I was trying to help stay off the streets.
Meaning what?
Meaning she was a longtime prostitute and drug offender.
How were you
trying to help her stay
off
clean?
the streets? What were you doing to help her stay off the streets?
Keeping her with me wherever I went when I was off work.
So did she live with you?
No.
Did she live at Mr. Damaris' home?
She stayed there quite often. She was friends with Mr. Damaris' wife.
All right. Then go ahead, continue. What happened?
After the game, when I went to leave, I got in an altercation with a drug dealer that she had called.
Okay, let me slow you down. You said y'all were drinking. What were y'all drinking?
We were drinking beer.
How much beer?
I probably had 3 beers, 3, maybe 4.
Anybody else drinking?
Everybody was drinking.
Yeah.
Like,
who all was inside? Where did you get in this argument or this altercation with a drug dealer?
Outside the house.
And how did that occur?
When I went to leave, he accosted me. He obviously thought I was Jay.
Why were you leaving?
Game was over. I had to go to work in the morning. I was going home.
You and Mr. Damaris did not get in an argument, and he didn't kick you out of the house and say, "Give me keys, don't ever come back"?
This is what they tried to say at the trial, but that never happened.
Okay, let's slow down a little bit. You had a trial.
Yes, sir.
Those were the facts that were presented to the jury.
That's what
Those
Rachel
were the
testified
facts
to.
that were presented to the jury.
I would imagine so. Yes.
Well, you were there, weren't you?
Yes.
And
But
the
I
jury,
never had an altercation with Jay.
and the jury came back guilty of manslaughter.
The second trial, yes.
Okay. Same facts were brought out.
I believe so. Yes.
Well, you were there, weren't you?
Yes.
How many murder trials have you had?
We had 2 trials.
Well, I understand, but I would assume you would remember, even though it was a long time ago, what was said at your trials.
They brought up a lot of things that just weren't true. They brought up the fact that they tried to say it was a fact that I was living with Jay, and I wasn't living there at Jay's house.
So how was it that you ended up shooting and killing Mr. Demarest? If you're involved with this drug dealer, how did you shoot Mr. Demarest?
I never shot Mr. Demarest.
Okay.
I'm convicted of shooting, but I never shot Mr. Demarest.
So
I
what
never
happened?
had a gun.
So what happened?
Mr. Demarest got in an altercation with this drug dealer over money that he owed him. And I ran. That's all I know. I heard the shot go off after I was in my truck.
And I assume, Mr. Anderson, that you told this same story that you're telling us today to 2 different juries. Is that right?
No, the first jury, the first trial I had, this is what I told them. The
Okay.
second trial, my lawyer advised me to just stay off the witness stand because they didn't have enough evidence to convict me.
He was wrong.
Excuse me?
He was wrong.
Well, obviously he was wrong. I didn't get to get on the stand in the second trial.
So your position is you didn't do this. You're an innocent man in prison.
Yes, sir.
So tell me what you've done while you've been in prison.
Excuse me, I couldn't hear
Tell me
that.
what things have you accomplished while you've been in prison?
I took 2 years VOTEC and completed that. I took anger management and living in balance.
Okay. And what did you get out of those programs?
I didn't get any good time.
I'm not talking about what kind of credit you got. What did you learn, or what did you understand, or what did you comprehend about yourself by taking these classes? You took an anger management class. Did you have
Yes.
anger issues?
Well, I took it because I was convicted of manslaughter, and I thought that it would look good on my parole.
So what you've done while you've been in prison is taken whatever it is you thought might help you get out of prison.
I took whatever classes that were available to me.
Okay, well, did you learn anything? Was anything of any value to you that you took? Or were you just sitting in there hoping to pad your resume for the time that you came before?
Everything that I've learned makes me who I am now. I don't understand how to answer that question.
Well, it's a very simple question. okay, you're probably going to go back to your cell and you're going to say, the guy who was questioning me was fairly aggressive at me. I don't think he believed me. That's what you get out of the discussion you and I are having today. What did you get out of the classes that you went to? Someone talked to you about anger. They talked to you about your emotions. They talked to you about your feelings. Did any of that resonate with you that, hey, that might be me?
Yes, sir.
I learned something from this.
Well, I learned to avoid confrontations. I learned to step back and take a deep breath.
What did you learn in living in balance?
It's basically what the way I lived it. I don't know how to answer that question.
There's nothing you can do about what I'm about to say, but you certainly have opposition to your release.
Yes, sir.
Law enforcement opposition, victim family opposition. You did have a DWI back in the day, I guess. So drinking, you still don't think drinking is an issue with you?
I've never had a DWI ever.
You didn't have a DWI? I thought I saw a DWI on your record. Maybe I'm wrong.
No, sir.
Let me look. Let me look. You might be correct.
It was operation with motorboat.
It was a reckless operation. Well, no, you had a,
It didn't really.
okay, all right.
We had a hit and run, but that was concerned.
Warden, what can you, Mr. Who is there with you there?
Excuse me?
Is there a staff member there with you today?
Yes, sir, Sergeant Marsh. However, he's housed next door at DC2. And for logistic reasons, he's here at DC3 for the hearing. So I can't tell you anything about him. I've never met the man.
Okay, thank you, thank you. Well, we appreciate you coming. All right, that's all I've got. Any questions?
I have one question.
Okay.
I have, good morning, sir. There was a arrest for fishing contest fraud. Do you remember what that was? What you did then?
Yes, ma'am. I was arrested for fraud for a fishing contest, the Grand Isle Rodeo. I won the rodeo, and I beat out the second place person was a judge in Lafourche Parish, and he complained about it. I was arrested for it. I went to trial for it, and I was found not guilty.
Oh, okay. Well, what were the allegations? You remember?
The allegations was that I didn't catch the fish legally.
Oh, okay. All righty. All right, that's all I had. Thank you for answering my question.
Thank you very much. Now we'll hear from Mr. Daniel Demarest.
Good morning.
I have a statement that I've written, but I'd just like to read to the board. Okay.
Yes, sir.
The scene of this horrific crime was our grandparents' home, where we used to go every holiday with my aunts, uncles, and all of our cousins. It was the place where we had wonderful memories of growing up. All those wonderful memories were wiped away on September the 6th, 2003, when Mr. Ruben A DOC shot my brother, Francis J. Demarest, in cold blood. Not the last memory I have of my grandparents' home is the stain of the pool of blood that my brother was lying in the next day. I was reminded of this of the crime scene in court as I saw for the first time the 4x4 white poster board with a picture of my brother lying on the ground with a white t-shirt with a hole in his chest and a pool of blood that he was lying in. What a difference to childhood memories we had. This home was at one time a political think tank for many prominent political officials from the city and loans, and sometimes served as their campaign deputies. My mother and father taught and showed us growing up that kindness should be practiced in our daily lives. There were instances when our parents would see a child in need and reach out to them to help them. When I was in the 5th grade, playing ball at a local playground, my mom discovered that there was one of my teammates that did not have clean clothes, but did not have enough money to buy cleats to play. My mom and dad went and spoke to his parents, and they asked if they could help. The next thing we knew, he was living with us and going to Catholic school with us. My parents paid tuition, bought uniforms, shoes, jackets, and all the necessary things they needed to go to school and play ball. There were many other examples of acts of kindness displayed throughout our childhood. Several acts of kindness my brother showed eventually got him murdered. He and his wife, Patricia Demarest, were separated and were living apart. Patty called Jay and explained that she had lost her job, and my brother's response was, "If you come live with me until you get a job and get back on your feet." He also allowed his killer, Ruben Anderson, and his girlfriend to live there with them when they were down on their luck. Ruben Anderson moved in, though he knew his girlfriend had open warrants for her arrest in Jefferson Parish. He was also harboring a fugitive, unbeknownst to my brother. After Jay's death, his estranged wife collected his insurance benefits and his pension up until her death just a few years ago. From the testimony of his girlfriend, the couple broke up the day of the murder, and then a fight ensued between Ruben and his girlfriend. My brother was not going to allow a man to put his hands on a woman. Then a fight broke out between Ruben and Jay. After Jay whipped his ass, he asked him to leave the house and give him his keys. He left and came back later, and Jay told him to get out and ordered him off the property. They both went outside, and Jay could be heard saying, "So what are you going to do with that gun? Kill me, you mother effer?" Then Ruben Anderson shot him at point blank range with a sawed-off 12-gauge shotgun. Not a gun used for hunting, but for killing. We were told by the coroner and one of the police officers that Jay could not have survived that gunshot wound. After Ruben shot him, he ran and drove off, not even trying to help Jay, which showed his true character. That to me shows no remorse, and that is characteristic of a cold-hearted killer. After this report aired on all of the news starting that night, September 6, 2003, Ruben's girlfriend turned herself in, and Ruben turned himself in the same next day. A brief history of our family: my father was an attorney and a reporter of mortgages for Owens Parish, and his father was that before him. My mother worked for the Department of Finance of the USDA, and as did my younger sister, Mary Lou. Jay worked for the Administrative Office of the Louisiana State Supreme Court. As you can see from the above, our family was all about servicing people and being outstanding members of the community. My father had parole power, and I can remember my father getting calls in the middle of the night on holidays and vacations to help someone get out, get parole. And he did it and never complained. In the appellate process, the defendant accused the court of partiality that the defense attorney knew my father, also an attorney, and rightfully so, because he knew almost all the attorneys who practiced in Orleans Parish, since he and my grandfather had held public office for over 50 years in Orleans Parish, where they worked with them every day. A tragic and horrific crime such as murder causes collateral damages with families, victims, members, and friends. At the time of the trial, no one knows the extent of that damage may be and never is considered. That could be multiple victims that this affects. The person who was affected most in our family was our mother. I'm sorry. My mother was born to a woman who did not want her at birth, so she never knew her mother. She was raised by her father and her grandmother. She had a hard life growing up and always wondered why her mother abandoned her. My grandfather and grandmother raised her the best they could, putting her through Catholic grammar school and high school. She graduated high school with honors and went on to work for the military at Camp Leroy Johnson in New Orleans. She met my father, Francis J. Demarest Jr., fell in love, and they got married. My mom gave birth to our older sister, Susan, and upon birth, my mom and dad were notified that she was diagnosed with an inoperable brain tumor, and my parents were told that this was terminal and that she could live with one or four of them. Unfortunately, Susan lived until she was 7 years old and died 1 week after her first sober communion. My parents were devastated; they never got over it until they had another child. My brother, Francis J. Demarest Jr. My parents cherished Jay because they believed that he was sent to them by God to make Susan's death easier to deal with. Jay went to St. Aloysius High School for 3 years and then finished at Brother Martin High School and was elected the first student council president. He graduated with honors and then attended the University of Notre Dame for 2 years and maintained a 3.5 GPA while he was there. He was feeling homesick, and after 2 years away from his family and friends, he returned home and graduated from Loyola University and received his bachelor's. He went on to work for my father as the chief clerk of the mortgage office. And then when my father retired, he went on to work for the administrative office of the Louisiana State Supreme Court, where he was employed until his death. Early on, I spoke about collateral damage of families at the time of crime like this is committed. Can you imagine the trauma and grief a mother goes through when she never knew her mother, and then both her oldest children are taken from her, one through natural causes and the other child taken from her by a heartless, stone cold killer? There are no words to say what my mother was feeling. And her reaction was when my sister and I delivered the news about Jay the next morning. She was distraught, angry, showing all the emotions you would expect of a grieving mother would share. This was compounded by all the bottled up emotions that were still there from Susan's death. So it's like she was grieving the loss of 2 of her children. This I thought was too much for her to handle, but faith got her through it. After Jay's funeral, the real tragedy began. My mother, who was strong German heritage, she had this tough exterior, but was the most sweet and gentle person on the inside, and loved her kids more than my footsteps. We saw that Jay's death broke my mother's will and spirit to live. She started not eating and drinking, and she was grieving Jay's death. You could see that she was starving herself and refraining from drinking. After a little over 21 months, my mom was admitted to the hospital. Not because of a medical condition or illness, her organs began shutting down, and she gave into life and passed away from a broken heart. The hardest thing in my life was watching my father tell my mother to die after they had been married for over 50 years. We were told that my dad would not be far behind because he would also grieve the loss of my mother. And it was just 9 months later and my dad was gone. In this case, this act of violence by Ruben A DOC caused 3 deaths in our family. By his cowardice act of pulling the trigger and now how does he even have the audacity to ask to be paroled? He made a conscious decision to leave the scene of the crime to get a sawed-off shotgun, came back with the intent and sole purpose of murdering my brother. My brother never got to see his godchild graduate from high school, college, get married, his 3 great nephews born, grow his mother and father's funeral. Victims' families versus convicts' families. Convict has possibility of visitation with his families if they so choose, possibility of parole, speaking of family through phone calls, letters, being set free.
Mr. Demarest, we've read your letters, but if you would just wrap it up, tell us if there's anything else you'd like to say. We do have your letter and we have read.
I'd just like to say that this is affecting our family deal. And this is something that will never be. It's something that carries you great. And I can just say this, that it has been, since the day this happened, it's been 7,353 days. And the last memory I have of my brother was Labor Day weekend, and we left. When he kissed me on my cheek, and his beard running against me. And I feel like everything wrong.
Thank you, sir.
Thank you, sir.
Mr. Anderson, is there anything you'd like to say before the panel votes?
No, sir.
Panel ready to vote?
Yes.
Mr. Anderson, I've reviewed your file and, I must say, I'm very disappointed in what I've heard today. I don't think you've been very honest with us about what actually happened. On one hand, on the other hand, I think you've been pretty honest about why you took these courses and what you hoped to do in taking these courses. I just think you've got more work to do. I'll accept the fact that if you want to continue to claim that you're innocent, that's fine. But I would have thought and hoped that you would learn something while you've been in prison. The damage that was done to the victim's family, all of those things some sort of contrition, some sort of understanding, but I haven't seen it. I didn't see it at all. You have law enforcement opposition. You certainly have obvious victim opposition. I think you need to do some more work internally. So my vote today would be to deny your request for parole. Mr. Rucci.
Mr. Chairman, my vote is the same for the same reasons.
Ms. Anderson, despite 2 trials, well, first of all, I want to speak to the victim's family. We really appreciate your participation in the process. I know how hard this was, but you know, the law is the law. He has rights just like you guys have rights, and I appreciate y'all coming today. And we did get to read the letter, and I put in my notes, it's one of the best letters I've had, and it's almost 8 years I've served. Very poignant, very poignant. But Mr. Anderson, I'm just really shocked that you lack no insight or awareness of the crime and its impact. You just presented none of that. No remorse, no insight or awareness of the crime. And the reasons I've already been stated, I'm gonna go back to my vote is denied as well.
Mr. Anderson, you have 3 votes to deny your parole. Good luck to you, sir.
Thank you.
I gotta tell you, he had me believing that he's innocent. We have had very few hearings where people come on and insist that they're innocent. I mean, unless they're just completely nuts. I do have a playlist called Innocent. Is he innocent? Or, check it out. I'll put it in here. There are just a few hearings that way. And I don't know. Well, what we'll do, and I haven't read it yet, but thank you, Richard, for providing it. We'll go over his appeal and let's read what's in the documents over there. And maybe we can come to a conclusion together. But I frankly am. I mean, to come up, to get a 30-year sentence, to have served 20 years, to know that all he has to do is come in and really just put on a good show. And he probably, it's manslaughter. He got manslaughter charge. He might have gotten off with the good interview. I believed him. Then you do bring up some interesting. He said he do bring up some interesting things. So he had the fishing fraud. I don't know if you guys are familiar with the recent. There were people who were caught putting weights in the fish, and it was a viral video. If you haven't seen it, go on YouTube and say weights in fish. They caught it on camera, and then they ended up getting prosecuted for it. He was saying it was a judge that he beat, and the judge and took him to court, and it's possible, Louisiana, I could see that happening, but it would have fared better for him if he had even just admitted that he cheated in the game. Okay, hold on, I'll be back. Okay, that was really cute, but he came running in with the costume he put on and wanted to show me. So what was I saying? But that he had me hook, line, and sinker, pun intended. And it was interesting what Mr. Mirabella said on the second trial. He's like, well, my attorney said I shouldn't get on the stand. And what did Mr. Mirabella say? Well, you should have gotten on the stand, or that was a mistake, which is interesting. I thought interesting coming from Mirabella, a former judge. And I didn't know what to make of that. They usually say don't get on the stand, right? But I don't know. That's interesting. And then you have the victim who comes on, and he really gives one of the longest statements that we've had without it being interrupted. And it seems like the guy's really hurting. He went into a lot, even saying that it's been 7,353 days since he last saw his brother. He's literally counting the days. But let's go through this document and see. I just wouldn't be surprised if he was innocent, just because of the fact that he was so adamant about it. And so let's go through this statement of facts. But there are crazy people out there, and we've certainly seen that. So Francis J. His life was taken by a single shotgun blast to his chest on September 6, 2003. Officer Michael Sam, responding to a 911 call placed by Mary Begg, found the victim's body on the ground at the rear of the driveway. Let me make sure my settings right now. Is this better? Okay. The victim's residence of Franklin Avenue. Officer Sam called for homicide officers to the scene. Sergeant Larry Green became the lead investigating homicide detective. He interviewed Miss Begg and checked the victim's residence. From this, he identified Rachel Lally and the defendant Ruben Anderson as a person of interest in this homicide. Sergeant Green disseminated the names and photographs of Lally and Anderson to the media. The next day, Rachel Lally appeared at the 3rd District Station because she had seen a report on television that the police wanted to talk with her. Sergeant Green interviewed Lally, and from that interview, he determined that the defendant had committed red rum. I don't say that in jest, I say it because of YouTube. He obtained an arrest warrant for the defendant, who turned himself in a day or two later. So he turned himself in. At the time he turned himself in, the defendant also turned his truck over to police. However, the subsequent search of the truck failed to disclose any evidence. So right now he has, it seems, a woman who is a woman of the night testimony against him as the only evidence to.
I'm not Chase. I like Chase.
Hold on. Okay. So at trial, the defense cross-examined Sergeant Green regarding his interview with Mary Begg and Rachel Lally. The sergeant stated that neither woman said she saw the defendant shoot the victim. Mary Begg did not testify at trial. Rachel Lally did testify at trial. She admitted that she had 2 felony convictions and was presently incarcerated. She also stated that when she went to the police regarding the homicide, she knew that she was wanted for probation violation from Jefferson Parish, and in fact was taken into custody based on that outstanding warrant. Lally testified that the defendant was her former boyfriend. She broke up with him early on the night of the homicide. Both she and the defendant had been living at the victim's residence for approximately 2 weeks before the homicide. So this is different than what he told us. But again, she is just the epitome of a bad witness, right? On the night that he was shot, she offered to help the victim clean out a closet. As they were doing this, the defendant began to harass her. The victim told the defendant to stop, but the defendant continued to verbally harass them. Ultimately, the defendant and the victim engaged in a fist fight. As a result of the fight, the defendant was bleeding from his face. So the defendant was getting the wrong end of that fight. But the victim, who was larger than the defendant, was unharmed. When the fight was over, the victim told the defendant to give him back his house keys and to move out. The defendant gave up the keys and left. A short time later, the defendant returned and knocked on the door. He asked to come in and retrieve his belongings. The victim allowed him back inside. However, words were again exchanged, and finally, the victim grabbed the defendant and physically threw him outside. The victim followed the defendant out. According to Lally trial testimony, she immediately locked the front iron gate and wooden doors so that the defendant could not come back in. A few minutes later, she heard the victim say, "So what are you going to do now? Shoot me, mother?" A moment later, she heard an explosion. She could also smell gunpowder. She told Mary Begg to call 911, and after struggling with the keys for a few moments, she opened the front door, went outside to check on the victim. Lally testified that she saw the victim with a wound to his chest, but she did not see the defendant or his truck. Lally further testified that when she walked away from the residence, and after that she then walked away from the residence, and after finding someone who would let her use a phone, she called a cab. She didn't call the police. She turned herself in the next day after seeing the news broadcast indicating that the police wanted to talk to her. She didn't call the police. She didn't call an ambulance. She left the guy on the floor. Not that he was going to make it with a shotgun blast to the chest, I doubt, but further testimony, Rachel Lally testified that she had seen a shotgun behind the seat of the defendant's truck at some point during their relationship. Oh, wow, this is real promising stuff. I'm telling from what I've read so far, this is like a weak case, but let's continue. She also identified a letter written to her by the defendant in October 2003. I once saw a shotgun in his truck. In a letter which she read to the jury, the defendant denied taking Jay's life. He stated that a man looking for money owed to him by Lally robbed him outside of his residence. The defendant claimed that he and the robber fought over the robber's gun. The defendant claimed that he and the robber fought over, and when the victim came out, the robber shot the victim. Okay, well, this is the part where this story does get bizarre. All right. That's just not like the odds are. I mean, I guess it could technically somehow happen. They're outside, and at that moment, this guy shows up, and then he fights. But then why does he drive away? And why, would he not? So yeah, this is the part where the story gets pretty sketchy. On cross-examination, Rachel Lally admitted that she had been using Pepsi and drinking vodka continuously for the 2 days prior to the time of the homicide. So she's pretty much out of it. She indicated that the victim and the defendant had also been doing a lot of narcotics and drinking. And I'm pretty sure he said he didn't do any of that. So maybe, maybe he's just in denial or something. He said he had 3 or 4 beers, but never touched narcotics. She also admitted that she had been a Pepsi abuser since 1982. Defense counsel, and this is 2003, so she's going on 11 years or something. Defense counsel elicited an acknowledgement from Lally that in her statement to the police, she stated that the fight occurred around 12:30 a.m., but that the 911 call was made at 2:49 a.m. So there was a 911 call now? Oh, this was the other woman who called 911? Okay. The defense also elicited that Lally is deaf in one ear, that she did not see or hear the defendant's truck leaving the scene, and that the defendant had told her that his shotgun was a 20-gauge weapon. Lally further testified that she broke up with the defendant because he invited Mary Begg over to the residence that night. Finally, she admitted that the defendant and victim were apologetic after the fistfight, and she did not hear the defendant threaten the victim. Dr. Richard Tracy testified that he performed an autopsy on the victim, recovered shotgun pellets and wadding from the body. He also noted that the victim had fresh scratches and scrapes on his knuckles of his right hand. Dr. Tracy identified the toxicology report, which indicated that the I learned something new today. I have two doors that lead to it goes through the laundry room, as many of you may know from hearing the laundry machine all the time. And it's an outside lock, but I locked myself in. He figured out how to turn the little lock thing and open the door, and I had no idea he knew how to do that. But hopefully we're safe now. I locked both doors. But he's in good hands, don't worry. Okay. So this is like literally the intervals between the stopping are pretty long. So just so you know, I'm not like all right. So Dr. Tracy identified the toxicology report, which indicated that the victim's blood alcohol was 0.19. And that's pretty high, right? Yeah, that's pretty high. And that the urine was positive for both Pepsi and Valium. Photographs of the defendant taken at the time of his arrest showed bruising around his face and ear and abrasion near his eye. Officer Kenneth Leary, an expert in the examination of firearms, testified that he examined the pellets and shotgun wadding recovered from the victim's body. He stated that the pellets were consistent with a 12-gauge ammunition. He further testified that the wadding was 12 gauge. He stated that the wadding could not have been fired from a 20-gauge shotgun because the wadding was too large to fit a 20-gauge weapon. He further testified that because wadding was found in the victim's body, the shot must have come from a fairly close distance. The defendant did not testify. This was the second trial. On that note, I think Miss Wise that said, you had two court hearings. You had two trials. Despite two trials, but it's like, well, he had two trials, but one of them was a mistrial. I mean, also it was interesting. It was nice Miss Wise said to the victim. I mean, I personally didn't connect to what he said, but it's still nice to say it, that he said is one of the best letters, resignated, something like that. It's nice to say it, whether it's true or not, and maybe it was true for her. For me, it was more like sad, because he just felt how his life has just totally been derailed by the loss of his brother. Now, the defense called two witnesses. They called two witnesses. That's it. Yeah, man. The first was Sergeant Doug Eckert, who participated in the investigation and the arrest of the defendant. He testified that the defendant made a spontaneous statement that somebody accosted him for money. The second defense witness was the defendant's father. He testified that he gave the defendant a 20-gauge shotgun when he was 11 years old. Well, he admitted, however, that the defendant was in his 40s and he had not lived with him approximately 20 years. Wow, this defense attorney he has seems to be a real great. He brings up his father, who says, I gave him a shotgun when he was 11 years old. Yes, it happened to be, 29 years ago, but couldn't you have called up other people? I don't know. Maybe not. The only possible error in patent pertains to the defendant's sentence and is raised in sole assignment. Okay. He said that his sentence was illegal and excessive. It was illegal based on trial's order that an entire 30-year sentence be served without parole. And I think because of Act 122, he became eligible for parole. Because it was a manslaughter charge. The judge, I think, threw them. So it shall not exceed 40 years. So the judge didn't completely throw the book at him. But it was not, the judge didn't believe him. because he gave him 30 years. He didn't give him 15. He didn't give him 20. He gave him 30. That if the victim was under the age of 10 years and was This is just going into his appeal. You know, I don't see anything else in here. What is this? You know, it's interesting though. The defendant, this was his first felony, and in his 40s. This is, that is an interesting point. He wasn't, he had some sketchiness around him. He had the fishing thing, which, maybe the Louisiana judges don't have the best reputation. But it was his first felony. This guy, he might not have been. Usually you would think someone who's addicted to and is hanging out with prostitutes and if he's really like, going on binges with him, that he might have something on his record, but he didn't. He all he has is a misdemeanor on his record. He was charged with second-degree homicide. The jury did not find him guilty of that. They found him guilty of manslaughter. So it was like the jury was kind of unsure. And I don't know how you can, it's one of those weird jury things where it's like, how could it be manslaughter, right? What they're saying is that he came back with a weapon, a sawed-off shotgun, with the intent to take his life. And it's like the jury's was like, we're not sure, so manslaughter. And that just doesn't make sense. The juries, sometimes they do things that just don't make any sense. But the judge did not he didn't take, the judge still gave him a 40-year sentence. Now, again, his only prior conviction was a misdemeanor theft. And they bring up some other cases where things worse were done, and they got lesser sentences. The state presented no physical evidence linking him to the crime. None. They don't even have the weapon. There's no weapon. There's no like gunshot residue testing. There's no eyewitness. The testimony was from someone who was locked up, who had a record, who is a self-professed addict and could have been getting something in return for this. I tell you, I mean, the problem is his story is so bad, is so like hard to believe, but it still is possible. It still is, it still is possible that something like that could have happened. But his story, but I tell you, let's see what they say. Lally's, extracurricular activity use, as I think Dr. Grande would say, was fully presented to the jury. The discrepancy in the times was also explored by the defense counsel. Nevertheless, Rachel testified that the victim forced the defendant out of the residence, and only a few minutes later she heard a shooting. Now, that's a few minutes later. Remember, she's been on a binge for 2 days straight. It could have been an hour for all you know, right? You're not getting. These are not quality witnesses. Notably, the defendant exculpatory statements pinning blame on an unknown robber corroborates that the shooting occurred only a few minutes after the victim threw him out of the house. The defendant did not contend in his statement or the letter he wrote to Lally. That letter is probably what did him in. He should have never written a letter. That is the part that makes me think he's guilty. Because he has a letter about how it happened. It just seems so ridiculous. That he was not on the scene when it occurred. Instead, he put forth a hypothesis of innocence that a man armed with a shotgun came along looking for money owed by Lally and shot the victim after the defendant and the robber struggled over the gun. Yeah, his story. This is it. This is it. In my opinion, I do believe he's guilty because this is just ridiculous. The version of events does not fit with Lally's testimony that the victim made a statement to his assailant and whether he was going to shoot him. Although the defendant argues that Lally's partial deafness would have precluded her from hearing the statement, the jury apparently believed her testimony and rejected the defendant's version of events. The decision should not be reversed. This is interesting. Testimony of Dr. Tracy on the issue is improper because Dr. Tracy was not established as an expert. However, the record establishes that it was the defense counsel who first asked Dr. Tracy about the effect of drugs and alcohol. So the defense messed up there by opening up the door to the doctor, which allowed the doctor to then, even if she wasn't an expert. The state did not ask any questions, no redirect, specifically noting a follow-up to defense counsel's question. Therefore, although Dr. Tracy may not have been qualified as an expert in a particular area, the defense waived any bias to objecting opening the door to testimony. I'm sure most of you get that. Oh, man. Moreover, the defense filed a motion to Lemine to exclude the tape. The 911 call was recorded. In the supporting memorandum, the defense asked if the call was admitted into evidence. The court excluded the portion wherein the caller, Mary Bragg, identified the defendant as the person who did the shooting. So she claimed he did it in the 911 call, right? And is not going to be present at trial, nor does the jury have the opportunity to observe her demeanor. The reason or reasons Mary Bragg was not going to appear at trial are not discernible. There you go. Why didn't his defense call Mary Bragg to the stand? However, contrary to the appellant pro se argument, there is absolutely nothing to indicate that her testimony would exculpate. Oh my gosh, I know the word, but exculpate him, assuming that she is the witness whom the state failed to disclose. Accordingly, the argument has no merit. Now, he said that there was that his counsel was ineffective, which is a very common claim in an appeal. But I mean, the counsel. I mean, I guess we didn't see the trial. It's not fair, but. He first contends that counsel failed to secure witnesses on his behalf, which he only called 2 witnesses, failed to ask for continuance to secure an expert to give Quito's testimony, probably should have done that, but I don't know what expert you would call. Does not name the, I mean, what expert would you call, right? I'm trying to think, like, what expert could he have called that would claim what I think I would have done? And remember, I'm not an attorney, but I think what you want to do is just go on to say how to say how their detectives messed up, how they zeroed in on just one suspect without looking elsewhere, how they took the testimony from someone who's has felonies and is not trustworthy, and they just even broke up, and it's just like totally, and that the police had messed up by not doing gun residue test, and that they have no weapon, and there's no, like, that's probably what you would have tried to focus on, and maybe his attorney did say all of that in his closing arguments and opening statement. He does not name the alleged witnesses, which his counsel failed to secure. However, there we go. There it is. See, that's the thing. He needs to, in the appeal, you need to say who you would have called. He had no one to call. He also contends that a law student was allowed to conduct the trial while supervising attorney did nothing. No. Oh, what? He also contends that a law student was allowed to conduct the trial while the supervising attorney did nothing, and the supervising attorney had a conflict of interest because of a deep affiliation with the family of the victim. Dude, can you imagine your life on the line and you have a student and you have a law student, not even an attorney, conducting the trial? Oh man, that is pretty disturbing. Oh man. Why? How is that allowed? I mean, now again, it could be this is his appeal. It could be that the law student really was just observing, and he's claiming it was the other way around. But and the conflict of interest part might be true too, but also might be made up. I mean, who knows? He repeatedly told his counsel that he wanted to testify on his own behalf, but his counsel refused. Whether any of these contentions have a factual basis cannot be discerned from the record before this court. He again refers to an unnamed witness. Sorry, I'm going on such a ramble. I don't know if you guys like this or not. I know it's going on pretty long right now. He again refers to an unnamed witness who would have undermined the case against him, and the prosecutor promised witness would be subpoenaed, but was not. The vague allegation referring to an unnamed witness is not sufficient to provide any relief. Accordingly, Simon never relaxed. For these reasons, hereby affirm appellate conviction. Further, we amend the sentence, the lead prohibition parole amended affirmed. And he lost. Now I just have to ask you, what do you think? What do you think? Man, the few things that I think why he could, okay, I could take the Dr. Grindley approach. And if you listen to him, I would say that he's probably guilty in reality, but not guilty beyond a reasonable doubt. You don't have a weapon. You have testimony from people who simply can't be trusted. You have, it seems to have, a police department that did nothing that they're supposed to do. There's no weapon. There's no evidence. The person who was it could have been that a dealer did happen to show up and do that. I mean, that is possible. And then the only people that are saying that that did not happen are just have no credibility. Not to mention that he shows up 20 years later and still professes his innocence and seemed to be honest throughout the hearing. He didn't play any game. He said, I took these programs because, whatever I wanted, Thought it would help. The fishing thing doesn't make him look good, but it's still possible. But that's what happened. And then they're kind of yelling at him by saying, after all of this time, you had 2 trials and you show no, and they're saying all of these things to him. But if you were innocent, if you sat 20 years in prison for something you didn't do, and your first chance of parole, I mean, it'd be understandable that you'd be bitter. It's kind of like the Shawshank Redemption parole hearings, right? But at the same time, he was like, come on, man, you had 20 years to prepare for this parole hearing. You could have just faked it for yourself, right? But, man, I know I said that I think he's guilty in reality, but innocent by a court of justice. But I'm torn between this one. You guys tell me, what do you think? What do you think? Well, with that, I'll let you go.